vote tomorrow will be conclusive and that we will turn this down and move ahead with more important business confronting this country. I yield.
Mr. President.
Senator from Wyoming.
We're having an interesting duel in statistics here because to take care of the 10% that the senator from Iowa says have a problem, we're going to turn the other 90% on their head. And it also doesn't surprise me that the President has put out a statement of policy, a SAP. I always thought those were pretty aptly named, but that would be oppose it, as I just explained. This is a regulation written by the administration, so I would expect that the administration would not like it and would veto it. There's only been one congressional review action that has succeeded. That was a rule on ergonomics, and what happened was they rushed through a 50-day regulation and at the Department of Labor, and then we had a change of presidents. And the other president didn't like it, so he was willing to sign the Congressional Review Act. This is not a waste of time. This is an important action. It's to warn boards that the ones that make the rules and the laws are Congress. And we delegate that authority, and it was delegated to the administration, to the National Labor Relations Board, and they're abusing their authority. What's changed? Well, there's the pre-election hearing. In the new rule, it says the pre-election hearing is solely to determine whether a question of representation exists. Now, the important questions, such as which employee should be included in the bargaining unit or the eligibility of an employee, won't be heard prior to an election. A hearing officer can unilaterally bar testimony or evidence as he or she deems not relevant to the question raised at the pre-election hearing under this new regulation. The effect? A hearing officer will have wide latitude to prohibit certain evidence before an election, even if such evidence is undisputed or stipulated, essentially leading to the conclusion that an election is proper. Under the new rule, parties are prohibited from seeking a review of regional directors' decision and direction of an election by a board. All issues to review will be heard after an election. Parties could seek a pre-election appeal only if the issue would otherwise escape board review. The effect? Parties with a legitimate legal bar to an election will be forced to run an unnecessary election. An unintended consequence is that an employer would have to commit an unfair labor practice in order to have their issues reviewed by a full board. That's a pretty high bar that they're putting in there, if you ask me. Okay, the new rule says that a 25-day waiting period between the direction of the election and the election date is eliminated. The impact? The 25 days allows parties to digest and understand the parameters of the regional director's decision to direct an election and for the board to rule on parties' requests for review of the decision. And the pre-election hearing will occur under the new rules, will occur 7 days after the filing of a petition, absent special circumstances. The effect, it forces employers to scramble to retain counsel. Again, we're talking about small businessmen here. There's no limit on how small of a business you can organize in this. So it forces employers to scramble to retain counsel, develop a strategy, prepare for a hearing, and develop evidence. Many employers, especially small ones, will be unable to provide a reasonable response so quickly, leading them to agree to a stipulated election. There isn't anything in this provision that gives any protection for the person that's in the middle class running a small business and trying to keep his business afloat. There used to be some protections, but this new regulation, and again, agencies do write a lot of rules, but they don't write ones to this significance, this regulation. As I mentioned, it's only the third time that it's been done by the National Labor Relations Board. It was done in a hurry-up situation. It was approved last year. 2 out of the 3 were done by this administration, and one of those has already been set aside by the courts, and that's not a very good record. And now we're trying to do this one in a hurry-up basis, and I think that there ought to be more consideration for it. part of the role of Congress is to take a look at what the administration is doing with their regulations, which we ultimately give them the authority to do, and to see if they're being done properly. So this is just a major part of the need for oversight. And thankfully, there's a process whereby we can get the right to debate this oversight, and that's what we're doing at this point. Okay. I yield the floor to Senator Brasso for such time as he needs.
Thank you.
Senator from Wyoming is recognized.
Thank you, Mr. President. Mr. President, I rise today in support of my colleague from Wyoming and the excellent work that he is doing, continues to do, the leadership that he continues to provide for all of the Senate, certainly for the people of Wyoming. He is the captain of our team, and I want to agree and associate myself with the remarks of the senator from Wyoming and express my concerns about the new ambush election rule that's been issued by the National Labor Relations Board. Mr. President, the board is a federal agency, and it's charged with conducting labor elections and investigating unfair labor practice charges. The appointed members of this board are meant to help facilitate a level playing field in the private sector workplace. Unfortunately, Mr. President, recent actions have demonstrated that the board is much more interested, in my opinion, in pursuing regulatory changes that favor unions. They should be focused on ensuring that workers are able to make informed decisions about their place of employment, not show favoritism. Let's take a little bit of a look, Mr. President, at the ambush election rule. On December 22nd of last year, the National Labor Relations Board issued a new rule. The rule, which greatly shortens the time period between the filing of a petition for union representation and when that election is held. Under the current rules, most union elections take place within about 38 days. Under the new rules, the time could be cut almost in half. The ambush election rule also narrows the scope of pre-election hearings while limiting the rights of a party to pre-election appeals. I believe that this misguided rule undermines the basic fairness in the representation election process. It limits the amount of information received by employees regarding the impact of unionization of their workplace. The rule also significantly restricts the ability of employers to educate their employees and to share their perspective. Well, I believe this causes harm to workers, Mr. President. The decision on whether or not to join or form a union is a very important decision for workers. Employment decisions directly affect an individual's ability to support their family, to pay their bills, and to sustain their livelihood. Workers deserve to have all of the information needed to make a well-informed decision. In order to seriously consider their options, employees must have the opportunity to hear from both sides on the implications of unionization. The ambush election rule, in my opinion, attempts to quickly rush employees through the union election process without giving those employees the full picture and a clear understanding of the issues. I have great concerns about what I believe is a disregarding of employer input. The ambush election rule disregards the rights of small businesses and employers across this country. The new rule is attempting to silence employers, silence them from discussing vital information to their employees about unionization and the impact on their lives and on their jobs. Under the new rule, employers would have a very limited amount of time to share their views, to provide counterarguments, and to explain what unionization would mean in the workplace. Employers should be allowed time to fully explain the information to their employees. Ultimately, I believe that the purpose of the recently released rule is to leave employers unable, Mr. President, to effectively communicate with workers about important workplace issues. The board is infringing upon the free speech rights of the employers. I believe that this new rule prevents employers from getting counsel. In these tough economic environment and times, small business owners are facing an incredible amount of pressure and responsibilities. Job creators are working hard to ensure that their products and services are competitive, that they're working to find available markets for their goods and services. They're trying to deal with the financial health of their businesses. Many small business owners are unaware of the complicated federal laws that they must adhere to during the union election process. Well, due to the variety of competing priorities and limited resources, small businesses all across this country often don't employ in-house legal counsel or human resource professionals familiar with unionization laws. Under the new rule, however, the time constraints will make it even more difficult for them to find appropriate counsel, to consult on the issues, and to prepare for the election process. Employers will be scrambling to find a labor attorney or a human resource professional to help explain their rights and to ensure that their actions are permissible under current law. As a result, many employers will be left at risk for unintentionally violating certain federal labor laws or silenced. The National Labor Relations Board should not be forcing employers to preemptively analyze federal labor laws and figure out how best to communicate their views of unionization just in case a union petition happens to pop up. Job creators should be focusing their scarce time and resources on managing and growing their businesses, on trying to put Americans back to work at a time of over 8% unemployment. Mr. President, I view this whole new rule as unnecessary. There is no reason for the new rule. The median time frame for union elections has been 38 days from the filing of the petition. About 91% of all the elections held in 2011 occurred within 56 days. These numbers indicate that the petitions and elections are handled and have been handled in a timely manner. Furthermore, the current election procedures are not impeding the ability of unions to win the representation elections. According to the National Labor Relations Board's own statistics, unions won about 71% of elections held in 2011. When I take a look at what's happening with the National Labor Relations Board, what comes to mind are the recent recess appointments made by the President. This new rule that we're facing and discussing today, this new rule is not the first time the Obama administration has attempted to use the NLRB to pursue the union's agenda. The administration continues to take actions and push through policies that are unwise and even, in my opinion, unconstitutional in order to do the bidding of unions. In an action that was both unprecedented and unconstitutional, President Obama's recess appointed 3 new members to the National Labor Relations Board during a pro forma session of this Senate. President Obama appointed 3 individuals. Now, the nominations of 2 of them, Sharon Block and Richard Griffin, were sent to the Senate only a few days before the pro forma session began. As a result, the United States Senate had no opportunity, none at all, to hold hearings or debate the nominees. President Obama completely disregarded the constitutional requirement of advice and consent for executive nominees. The appointments were a heavy-handed effort by this administration to curry favor, in my opinion, with the unions. Mr. President, I come to the floor as someone who has talked at great length about the impact of regulations and how they make it harder and more expensive for our small businesses to hire people around the country. And when I look at this, I have to tell you that businesses already are having trouble keeping track of all the changing rules and trying to abide by all of the new requirements they face on almost a daily basis. The only certainty being offered to the job creators in the United States is that the Obama administration is going to continue to change the rules of the game on businesses to meet its own agenda. The ambush election rule is the exact type of regulatory change that makes employers nervous and reluctant to expand their businesses, to create new jobs, to hire and put people back to work. This federal government should be focused on giving employers stability, predictability, and opportunities in growth. Instead of giving them opportunities, what we see is stacking the deck in favor of labor unions. And so I come to the floor, Mr. President, as I know my colleagues will as well, in a call to action, and that's to employ the Congressional Review Act. Under the Congressional Review Act, Congress is able to overturn the ambush election rule by passing a resolution of disapproval. I'm proud to be an original co-sponsor of Senate Joint Resolution 36, introduced by Senator Enzi. The resolution of disapproval rescinds the new union election rule issued by the National Labor Relations Board. Now, unless Congress takes action, the new rule is scheduled to take effect on April 30th of this year, just the end of this month. Well, I call upon the Senate to pass Senate Joint Resolution 36 and prevent this dangerous rule from silencing employers and hindering the ability of American workers to make informed decisions. Thank you, Mr. President. I yield the floor.
Mr. President?
Senator from Wyoming is recognized.
I'd ask unanimous consent to have 17 support letters submitted for the record.
Without objection.
A few of the ones submitting letters are the National Federation of Independent Businesses, the Associated Building and Contractors, the Association of Equipment Manufacturers, the Coalition for a Democratic Workplace, the U.S. Chamber of Commerce, National Association of Home Builders and Manufacturers and Wholesale Distributors, National Council of Chain Restaurants, the National Grocers Association, the National Roofing Contractors Association, and the Retail Industry Leaders Association, to name a few of them. I'd also ask unanimous consent to put in the record an article by Phil Kerpen in the Daily Caller, "Will any Senate Democrat stand up to Obama's NLRB?"
Without objection.
And unless there's further debate, I would yield back the balance of our time for today.
President.
Senator from
This side yields back
Iowa.
the balance of its time for today, too. Anybody else want to talk? Not today. No.
All time having been yielded back under the previous order, the Senate will resume consideration of the motion to proceed to S. 1925.
President.
Senator from Wyoming is recognized.
Thank you, Mr. President. I suggest the absence of a quorum.
The clerk will call the roll.
Mr. Akaka.
Mr. President.
Senator from Connecticut is recognized.
Thank you, Mr. President. I ask that the quorum call be lifted.
Without objection.
And I ask that I be permitted to speak as though in morning business.
Without objection.
Thank you, Mr. President. On this day, almost exactly at this hour in Bridgeport, Connecticut, the L'Ambiance Plaza became a scene of devastation and destruction and death. Every year, almost every year in those 25 years, we have commemorated that destruction and tragedy with a ceremony, and we did the same this morning in Bridgeport. We went first to the site, and then to City Hall, and then to lay a wreath at the memorial for the 28 workers who were killed on this day 25 years ago. L'Ambiance is ground zero for worker safety, and I rise today to talk about all who have been injured or lost their lives because of unsafe work conditions. L'Ambiance Plaza was a tragedy, but it was not the result of human error. It was the result of an employer cutting corners to put profits above safety. It was an avoidable and preventable catastrophe. One of the tasks that we have as public officials is to assure basic safety for our citizens, particularly for workers who leave their homes in the morning hoping for nothing more than to come home at night to their families, put food on the table, and a roof over the heads of their children. Those 28 workers who perished on this day 25 years ago wanted nothing more than those simple opportunities that should be guaranteed in the United States of America, the greatest nation in the history of the world. In protecting workplace safety, we have an agency called the Occupational Safety and Health Administration, known as OSHA, and it is charged by this Congress and every Congress since its creation with setting standards and providing for enforcement of those standards so as to assure basic safety for workers when they leave home every day and they go to their jobs. In Bridgeport, at L'Ambiance, a technique of construction known as lift slab was in use. It was under review by OSHA. It had been under review for 5 years before the L'Ambiance collapse. In 1994, years after L'Ambiance, it was prohibited unless certain conditions were met. If that standard had been in effect on this day 25 years ago, 28 lives would have been saved. This morning, I was in Bridgeport for that ceremony with many of the families who must live with the tragedies of their loved ones having perished needlessly and tragically on this date. There were speeches. There was a bell-ringing ceremony. There were tributes not only to the workers and their families, but also to their brothers and sisters who searched with a ferocity and determination in the hours and days for their remains after it became clear that they could not be rescued. But none of today's ceremonies or any of the other ceremonies in the past 25 years can bring back those workers who perished because lift slab construction was used on that site. And when the upper story fell first, all of the bottom stories collapsed as well, meaning that those who worked under that top story could not be saved. And eventually, when OSHA adopted the standard to be applied to lift slab construction, it said no one could work under that top story when it was put in place. OSHA, in short, recognized the hazards of lift slab construction well before L'Ambiance collapsed. And its inaction over the process of adopting those regulations, the 8.7 years that it took to adopt the standards, contributed significantly to the collapse that occurred 25 years ago to this day. I wish I could say that OSHA has learned from this horrific incident at L'Ambiance. I wish I could say that the standard setting that is so necessary to be achieved promptly and effectively now is done routinely. Unfortunately, the contrary seems to be true, and I want to thank Senator Harkin, the chairman of the Senate Committee on Health, Education, Labor, and Pensions, for a hearing last week that illuminated so dramatically how much work is still to be done. The GAO has done a study showing that the average length of time to complete those standards is more than 7 years, that figure takes into account the standards set since 1981 to the year 2000. The final number of regulations published by OSHA has declined every decade since the 1980s. While 24 final standards were published in the 1980s, only 10 final standards were published between 2000 and 2010. Workers are still at risk because regulations are delayed for years. And just as one example, the dangerous health effects resulting from the inhalation of silica dust found in common sand have been widely known for many years. Silica dust has been classified as a carcinogen to humans by the United States National Toxicology Program. It is a known cause of lung cancer, and silicosis is an often fatal disease. And yet, despite the scientific evidence and the hazards associated with silica dust, its use on work sites across the country is ineffectively regulated by inadequate OSHA standards, and those standards have been on the books since 1972. Preventing the dangers of silica is simple and easy. Employers simply must ensure that when cutting materials, the blade must be wet to ensure that the silica dust is not airborne. Simple and easy solutions that can be achieved by standards that OSHA has a responsibility to set. According to OSHA agency officials, they began work on updating the ineffective silica standards back in 1997, more than 14 years ago. The most recent draft proposal for a new silica standard was submitted for review to the Office of Management and Budget, OMB, in February 2011. OMB has been processing that draft for over a year, and in the meantime, workers are put in danger, workers contract disease, and workers are put at risk of fatal disease. These lengthy delays are simply unacceptable. As the L'Ambiance tragedy demonstrates, standards delayed is safety denied. Workers and their families suffer real-life consequences when the federal government fails to implement effective standards protecting people in their workplaces. OSHA itself estimates that up to 60 worker deaths per year could be prevented by strengthening the silica regulation and other regulations from 1972, and yet the new rule continues to be delayed by procedural and political roadblocks. There's still work to be done, and I hope that we will make progress under Senator Harkin's leadership on an OSHA rule making standards more effective and more easily adopted. There are a number of steps, simple and easy steps, that can be adopted. Expediting approval of safety standards is one of them. Despite a general consensus within industries on permissible exposure limits, that is PELs to dangerous chemicals, OSHA rules for hundreds of those chemicals haven't been updated for nearly 4 decades. OSHA should direct, and Congress should direct OSHA to update obsolete PELs to reflect consensus among industries, experts, and reputable national and international organizations. Easier court approval also must be enabled. The current standard for judicial review is a major factor in affecting the timeline of OSHA's standard-setting process. The existing substantial evidence standard requiring that OSHA research all industrial processes associated with the issue being regulated is disproportionately burdensome when compared to the requirements placed upon other federal agencies, and the standard should be reevaluated. And finally, deadlines and timelines for standards setting should be adopted, directed by the Congress to minimize the time it takes OSHA to issue occupational safety and health standards. Experts and agency officials agree that statutory timelines for issuing standards should be imposed by Congress and enforced by the courts. I look forward to working with my colleague on these measures and others, and I hope that the memory of those 28 workers who were killed 25 years ago on this day will inspire and move us to take action as quickly and effectively as possible. But each year, others are added to that list in other sites in Connecticut, 49 last year alone, and around the country, hundreds in the states of my colleagues here in this body. Let their memories also inspire us to redouble our efforts to protect people in the workplaces around Connecticut and the country. Thank you, Mr. President, and I yield the floor. I note the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.
Mr. President, Senator from New Mexico. I would ask to vitiate the quorum call, Mr. President. Without objection. And I would ask to speak for 10 minutes as within morning business. Without objection. Mr. President, I rise today in support of my amendment to strike Section 208 from the Postal Reform Bill. Section 208 would authorize the U.S. Postal Service to move to 5-day delivery service within 2 years. The U.S. Postal Service faces significant financial problems. Changes must be made for the Postal Service to adjust to a digital world. The budgetary concerns are very real. We all know this. But an imminent reduction of service to 5 days a week is not the answer. Number one, a shift to a 5-day service could result in the loss of up to 80,000 jobs nationally. Is this the time to be proposing 80,000 layoffs? Two, 5-day service would undercut a market advantage that the U.S. Postal Service currently has over its competitors. And three, especially in rural America, many of our businesses and most vulnerable citizens depend on 6-day postal delivery. Newspapers, advertisers, pharmacy delivery services, senior citizens, all could be hurt by the loss of Saturday service. Last week I met with the community of Mule Creek back home in New Mexico. Mule Creek is small and rural. Folks there told me they have no cell phone service, no high-speed internet. They depend on their post office. It is the lifeline, the center of their community. And not just 5 days a week. For many working people, Saturday is the only day they can sign for packages, including for delivery of prescription drugs. I know that some of my colleagues believe that moving to 5-day service is necessary because of the Postal Service's financial problems. But we need to give the changes we're making in the bill a chance to take effect. 2 years simply isn't enough time before we make such a drastic and far-reaching change. We should not rush prematurely to 5-day service. I urge support for my amendment to protect jobs, to strengthen the competitiveness of the Postal Service, and to protect the millions of Americans who depend on that service. Mr. President, I note the absence of a quorum.
Clerk will call the roll. Mr. Akaka.
Mr. President,
Senator from Tennessee.
I ask unanimous consent that the quorum call be vitiated.